going to start because we've got people who are dialing in and they'll be wondering what we're doing if we wait too long. Welcome everybody. I'm really glad to see that a number of people who I know to be extremely busy have turned up to hear what Anneli has to say. Welcome, Anneli. Thank you ever so much for coming. This is one of a number of sessions where you've participated or spoken to us. The last time was incredibly well received across the firm. And we're very, very grateful to you for coming in today to talk about the withdrawal bill. On that note, Anneli, I will let you start.
So I think last time I spoke to you, I was fresh out of the Supreme Court and full of the miller's tale and all the certainty that the judgment provided about the UK's constitutional requirements. And now we're 9 months further on, and we've had the Article 50 notification, and it looks like this conception is really going through some arduous labour. And those certainties that we thought we did have are not proving to be the case. If anything, it's getting more and more complex and more uncertain. And in July, the government published the draft of the... I still can't stop calling it the Great Repeal Bill, I'm sorry. If you try and call it the European Union Withdrawal Act, you end up with which doesn't really bode politically well. So I'm going to call it the GRB or the Great Repeal Bill, affectionately. So this currently faces over 150 pages of proposed amendments. I think it's over 400 in total. So that the government has had to extend the normal time period. They normally have 8 days to carry out these amendments. They've actually had to spread it over 8 weeks. And what I'm trying to do in today's session is to give you a whistle tour of the main provisions of the bill and the likely crunch points. I'm not going to focus on the deficiency powers in Section 7 and the Henry VIII clauses, because I think there's so much ink that has been spread on those in the media and by lawyers that I don't think I've really got much to add. And actually, when you look at them, they're not as bad as we originally feared. I mean, yes, they're incredibly wide, and in theory they could be used to correct things, but actually I think the controls that are put in place are quite sensible. What I want to focus on are the other clauses of the bill, which I think really will have very far-reaching consequences for the UK legal system as we know it. And in a way, the Henry VIII clauses are a bit of a Trojan horse, because all the attention's being diverted onto those, and people aren't really looking at the detail of the rest of the bill. So I want to point out some of the complications that are going to arise. I can't promise that I've got answers to all of those complications, but at least I should give you some food for thought, and hopefully we can have some discussion. So I don't want to sit and lecture at you, so if you have got questions and you do want to raise things with me, please interrupt me or tell me if I'm going, but especially I don't know if you've got foreign officers here today. Is anybody from abroad?
I think it's mostly UK.
Mostly UK.
Mostly UK.
But yes, please stop me, interrupt me, whatever. So let's dive in with the first clause, which is the repeal of the 1972 Act. Now that's one clause and 2 lines, and that's all it takes to repeal 44 years of European jurisprudence. You could be, persuaded this is really quite a straightforward exercise. If only life were that simple. But no, what clause 1 is doing is it's turning off that conduit. Remember the Supreme Court talked about this tap that had the flow of European law rights coming into the domestic legal system. And clause 1, in a very few words, is turning off that tap. So EU law is no longer going to have direct effect, and it's no longer going to infiltrate into our legal system. But don't fall into the trap of reading the clauses of the bill in isolation, because the devil's in the detail, and you've got to marry up all these points that are scattered across the entire body of the bill. It's a complicated jigsaw. So it's only when you look at the other clauses that you can see the government's really is hammering on the nail, putting the nail on the head, that there is going to be no direct effect of EU law, and there's going to be no indirect effect of EU law after Brexit either. So under clause 5, the doctrine of supremacy after Brexit is dead. There's no direct effect. There's no consistent interpretation. That's clause 6. There's no complaint to the Commission, there's no preliminary references, there's no Frankovich damages, and there's no JR based on the invalidity or erroneous interpretation of EU law. So really this is the death knell for European law, certainly as we know it, and it's going to pose quite a few constitutional questions, not just for our future relationship with the EU, but also for the government's internal relationships with the devolved administrations. And it's quite interesting, if you have a look at the amendments that have been made or proposed, you can really see where these crunch points lie. So I'm going to just pull out a couple of key points that come out of those very two succinct lines. One thing you have to understand the bill is that it is drafted on the doomsday scenario that there is no deal at all. Okay, so it's not trying to legislate for the future relationship at all. Certainly not legislating for any transitional regime. This is a preservation device to keep the legal system on track as if we leave without a deal. And anything else that comes in through the negotiations or through a transitional deal will be in different legislation. So anything that you try and say, but what about the future? What about the implications down the track? No, this bill is not designed to deal with any of that. That will be the subject of future legislation. So key points. One, well, what does exit mean? And you'll see there's a number of amendments that are trying to claw back that exit should just mean exit from the EU treaty. It doesn't mean exit from Euratom, exit from the EEA single market, exit from the European medicines arrangements or the aviation security arrangements or any of those other multilateral agreements. So again, how complete is exit going to be is up for debate. The Act is going to be repealed on exit day. And then you would have thought, well, come on, Article 50 was triggered on the 30th of March. That means we're out on the 30th of March 2019. But no, that's been left to ministerial discretion. So Brexit day may shift. And there's even provision for the minister to change the Act itself. So conceivably, if there was a change of government, there could be a cancellation of Brexit altogether. Then there are a number of other amendments that are trying to make the actual departure conditional on certain triggers. So there's one amendment by Chuka Uman and Stephen Doughty and Stella Creasy saying, well, this will only take effect, the Act will only be repealed on the condition that there is a prior deal regarding the future trading relationship. So that we're not into that horrible vice that Article 50 creates of if there's no deal, you leave without anything. So they're trying to build back in conditions to make sure there is a deal. And again, there's another amendment trying to make sure it's conditional on there being some kind of transitional arrangement. The real knotty issue is, well, what formalities do we have to comply with before we leave? What are our constitutional principles here? And obviously this is quite untested. We've had the Miller case, but what do we need in order to leave? Because one element of the government says, well, we've served the Article 50 notice, that's it. We don't need anything further. That we've got the Act of Parliament for that, and now the executive has been given full authority to negotiate and leave. And the terms of that mandate are very simple, very clear. There is another opinion, and you may have seen the Three Knights opinion that's been given by Sir Jeremy Lever, Sir David Edward, and Sir Francis Jacobs. Those three luminaries of EU law have said, no, if you analyse Article 50 and you analyse what constitutional principles means, you can't have a situation where the European Parliament gets to vote on this deal, so all the heads of state of the national governments get to vote, and yet our own supreme legislature doesn't get a proper say on the final deal. So the Three Knights opinion, which I think was published back in March or April, says no, there has to be a further Act of Parliament, and that can't just be an approval or a motion before the House of Commons. That has to be a proper act going through both Houses of Parliament in order to approve the deal. So then you get to questions, well, how's that going to work? Because does that approval take place before the European Parliament vote? Does it take place after the European Parliament vote? And what happens if either house rejects the deal? Because then you're left in this stagnation of, well, if there's no deal or you reject it, you leave without a deal. So there's really no meaningful vote at all. And so Caroline Lucas has put an amendment in saying that, if there is a rejection of the deal, then there must be a maintenance of the existing membership on existing terms, and we revert back to maintaining within the EU. I'm not sure any or all of these amendments are going to work. A lot of them I don't think are very consistent with Article 50 itself, but you can see the scale of the battle that the government has ahead to get this through. Another issue is the devolved administrations, because of course they've had the Scotland Act, they've had the Wales Act, and the Northern Irish devolution, which certainly those devolved governments understood was a proper consent mechanism, a proper consultation and a proper consent. And that seems to have been watered down, certainly in the Miller judgment, that it's not actually a right of veto or a right of approval. It's just nothing more than the original conventions that were given. And then the last thorny issue of, well, what happens if there's no deal? Because there will be nothing for Parliament to review or approve. And under Article 50, that 2-year clock is ticking. When the 2 years is up, like a countdown scenario, if there's no deal, then we leave and we'll be on WTO terms. And then the recent indications that have been given by the US and a number of other signatories is that they are not prepared to allow the UK to continue on the EU schedules of tariffs, and then we're going to have to negotiate a whole new separate schedule just for the UK with 160 WTO members. And if you think the Uruguay rounds in 1994 were the last successfully completed rounds of negotiation, and the Doha rounds since then in 2000 failed, that's no mean feat. So then the other elephant in the room is, well, what happens in that scenario, and is there the possibility of Article 50 being revoked? And is that within the framework of either Article 50 itself or within the scope of the principles of international law if you apply the Vienna Convention? So you can see immediately those two lines immediately give rise to a load of thorny issues that are either going to have to be resolved in the parliamentary process or possibly in the courts later down the track. So let's move on to the next topic. The next topic I've got on my list is repatriation, and that's clauses 2 to 4 of the bill. Because you would think, well, actually just repealing an act is quite straightforward, isn't it? We have the doctrine of implied repeal, and any subsequent act that's inconsistent with a prior act, it's repealed. That's end of story. But it doesn't quite work when you've got the EU law, which has infiltrated over 60% of our statute book. So if you're trying to rip out the EU elements, it's a bit like taking the egg out of the omelette, and you're going to be left with a very rather unholy legal system, because the Act itself is only one manifestation of EU law. If you think of what Schedule 2 does, it brings in all those regulations, all those decisions and directives, and you're looking at over 45,000 different legal instruments that have to sort of, if we want to have continuity for business, and we want to have legal certainty, and we want to safeguard people's rights going forward, then those provisions have got to be there's got to be a gap filler. Those provisions have got to be carried across. Otherwise, the system is simply going to be dysfunctional and it's not going to work. So clauses 2 to 4 of the bill are designed to fill that gap and to maintain continuity while the negotiations are ongoing. So if you look at the Canadian trade agreement, that took 7 years to negotiate and a further 2 years to implement and ratify. So we're probably looking for well into the next decade of needing some continuity of those provisions. And so we've got 18 saving clauses, as they're called, and schedules, which operate a bit like Microsoft patches. So you plug them into the system, and it sort of gives it an operational upgrade to maintain security during that process. And I'm just going to pull out some points from each of those clauses, because it's drafted in quite an abstract fashion, and you've got to drill down into each element of it to see, well, actually, what does that mean in practice? What does that mean for people's rights? What does that mean for enforcement? And how's the system going to work once we go? So clause 2 is designed to maintain what they call EU-derived legislation. And that's got a very wide definition. It covers all domestic implementing legislation. So the prime example is a directive where you've had to, under Section 2 of the 1972 Act, you've had a directive that's had to be implemented within the legal system. So the intention is, why they've kept it so broad, is they want to stop the doctrine of implied repeal. So that just because at some point there's an inconsistent statute later on, those rights aren't overridden. So they're trying to wrap everything up in Section 2. But that doesn't mean that these rights are going to continue in the same way as previously enjoyed. If you look at Section 2, it takes across the text of the right. It doesn't actually build the right into the legal system. And you may think, well, what's the difference? You know, if it's written into the book, into the statute book, then the right's there. But you've got to drill down and realise that it only takes effect in domestic law. And that the government is very clear that that is not the same as the current effect that it has under EU law. And you only get that by, again, reading the other provisions of the Act. So you've got, this is subject to all the limitations in Clause 5 and Schedule 1. So there's no duty of equivalence, there's no duty of effectiveness, there's no duty of the court's duty of consistent interpretation, there's no duty of sincere cooperation, there's no fundamental principles, so you don't have issues of proportionality, you don't have issues of equality which overlay the scope and exercise of those rights. And they will only be subject to UK remedies, so the remedies that are available at national law. And Schedule 1 makes very clear that there's no right to Frankovich damages. The government is going even wider and saying, well, there's no right to any remedy that's been created under EU law. So for any of you that are public procurement lawyers, where there's a specific remedy in the public procurement directives, those remedies will no longer apply. Query competition law, where the court has created this direct right to contractual damages for cartels and abuse of dominance, is that a Euro remedy? Or will it be treated as a national remedy? Even when we go back to the cases, fact-obtain cases. Do you remember back in when we were studying law or some of us were back in the 90s, that there was no right to an injunction against the Crown at that time, and it was only because of fact-obtain that they said you've got to take that bar away if it's denying effective relief. So all these sort of examples where the national courts have had to finesse the domestic remedy book to give effect to EU law rights are going to fall away. So it's going to have quite important ramifications for judicial review. If you don't have these rights to an injunction against the Crown, you can't demand specific performance, and you haven't got proportionality as a ground of review. So it's going to be quite large-scale changes for those of us that are litigators and also for the judges in applying and enforcing this new regime. So that's Clause 2. Clause 3, similar points. Now this applies to directly applicable EU legislation. And this is intended to catch parts of EU law that have never had to be implemented because they were always directly applicable, mainly regulations, but also Commission decisions or decisions of other enforcement bodies, or what they call tertiary legislation. And there's quite some strange anomalies that these definitions give rise to. So if you think back to your early days of EU law, everything used to be done by regulation because the EU had a bit of a hammer to crack a nut. It wanted to establish harmonisation, and it dictated the format to member states to make sure that they were compliant. And then there was a gradual shift where we moved to mutual recognition, and they allowed member states more latitude and said, well, we'll do it by directives, and then you can have the choice over how the form and the method of implementation that fits your legal system. And the bill ignores that distinction. So we end up with this random and arbitrary distinction where regulations, which there aren't that many of them nowadays, will automatically be carried across into the domestic statute book, but directives won't be. And importantly, where you've got some directives that are still in the pipeline, so there's quite a few going through the trilogue process at the moment, they may be enter into force before Brexit Day, but then they normally have a 2-year implementation date. So they're going to straddle Brexit date. And there's some really important directives that will not be carried across because of this rather artificial watershed of the Brexit dateline. So examples of this, there's quite a wide range of reform to the services directives, which are going to create a kind of passport for small businesses in particular, but also wider service passporting, which will not be carried across. The second audiovisual services directive, which means that any, and it's got quite a sizable part of our economy, any kind of broadcasting program that we have at the moment, where it's Sky Sports or CBBS, or even it's going to be extended to Netflix and video on demand. We at the moment can package that, and all we have to do is dub it into different languages. But it's one format, and it's sold across all 30 states of the EEA under this passporting arrangement. And there's a new directive that's going through the pipeline now that's going to introduce new regimes for Netflix, for social media, so Facebook, and for video on demand. And that implementation will fall after the Brexit deadline. So that won't be carried across. So there's some strange reasons why those directives should not be countered. And you think of whole industry sectors that are governed by directives now. So you've got the rail package directives, you've got the telecom directives. Those regulations, if they're updated or due for updating, will not be carried across. And the same goes for soft law. You know, a lot of regulated sectors are run through Commission guidelines. So you've got the vertical exemptions guidelines that are due for a renewal. And companies are self-assessing their agreements for 5 years on the basis of those guidelines, but they may not be included and carried across. You may have staff working documents, competition lawyers amongst you. You've got all these working documents on what overcharges, what a new one coming on, pass on. They're not going to be carried across either. And the other strange anomaly is that this, I think I mentioned this in the last talk I gave, it's going to take a snapshot of the law as it was on Brexit Day. And that will be copied like a carbon copy imprint and put in our statute book, but then it's fossilised in time with no guarantee that as the EU law evolves and new legislation comes online at a later date, or there's new rulings from the ECJ, there's no guarantee that any of that will be reflected. And you may think, well, come on, we're leaving. Of course we're not going to keep in tune with what Europe's coming out with. But if you've got regulated sectors that are based on these common regulatory frameworks, and you've got judicial cooperation or you've got regulatory cooperation, it is quite important that there is some consistency in approach, particularly if you've got global enterprises active in different member states. You're going to have distortions of competition, and you're going to have an uneven playing field. So there are quite serious ramifications down the line, but this bill is not intended to deal with that. That is to be dealt with at a later date. So that's clause 3. And then there's a strange clause, a wrap-up clause in clause 4, which is for any other matters covered by what used to be section 2.1 of the 1972 Act. So we're repealing section 2.1 on one hand, and then in clause 4 we're bringing it back in again. But it's just not called section 2.1, obviously. It's going to be called section 4. But in purpose and intent it's exactly the same. And so this carries all treaty rights and all case law judgments, rights that have been recognised by the Court of Justice up until Brexit Day. So where the Act, you have to understand how the Act works. It's an Act of two halves. So the first half of the Act is the Giving Act. And it's giving these rights and maintaining continuity. The back end of the Act is the Taking Away Act. So it really is a Janus Act. It's got two faces, one creating rights or maintaining them, and the sting in the tail is the exceptions in Section 5 and Schedule 1. It's a bit like what the Lord gives, the Lord takes away. So rights are created, but then they are switched off to a significant degree in the back tail end of the Act. And I don't think many people have picked up on this. Everyone's talking about the Henry VIII clauses, but they're not looking about what actually this means for enforcement of rights. And so clause 5 says, right after Brexit, there is this Brexit watershed. Everything maintained up until Brexit Day, but after Brexit Day, it's the brave new world. There's no supremacy of EU law. There's no Charter of Fundamental Rights. And you think, well, that's fine, you know, we're leaving. Obviously, there's got to be an end to EU law if that's how the vote went and people want to leave. But you don't understand, it's not clear from the bill anyway, what these concepts mean, because they're using supremacy as a kind of a term of applying the hierarchy of rules after Brexit. But they're using an EU concept to define that. And you think, well, are you talking about UK, a new concept of supremacy that we don't know what that means yet? Or are you talking about EU primacy? And then if you are, you're bringing in fundamental principles like proportionality, effectiveness, sincere cooperation. But at the same time, Schedule 1's taking those all away. So there's a lot of inconsistency in the back section of the Act, particularly between Section 5 and between the schedules. What is another inconsistency? Section or Clause 5.5 brings in fundamental principles, but only to interpret provisions and rights. Schedule 1 says you cannot rely on a fundamental principle as a right of challenge. So although fundamental principles, and there are vast numbers of them, you know, we think, oh, equality, effectiveness, what does that really mean in principle? But in every single sector, it has its own fundamental principles. So in environmental law, you've got polluter pays principles. In telecoms, you've got the user pay principles. And that applies in other regulated sectors as well. There's a whole equality and discrimination, who's the concepts of workers, the concepts of direct and indirect discrimination. All these concepts apply to interpret the scopes of these rights. But then when you want to try and challenge a right and enforce those rights, you can't actually use them as a sword. You can't use them as a ground of challenge at all in Schedule 1. So what you really need to look at is actually what does it mean to have a right in reality? Go back to kind of basics of being a law student again, because it's not just enough to have the text of the right written into the Act. They've got to be interpreted and applied by judges. And if Schedule 1 and Clause 5 are switching these rights off, where is that leaving people with their rights, and where does it leave judges in knowing how to apply and enforce them? Because if you look at Schedule 1, which really is the switch-off provisions, these are drafted in very, very broad terms, and there's no time space there. So they apply to cases even where the facts arose before Brexit Day. So normally you would have your dispute, the grounds giving rise to your dispute, and then you have a 6-year limitation period. So conceivably you could think of something that could happen the day before Brexit, say on the 28th of March 2019. Normally you would have a 6-year limitation period to enforce your rights for that breach. But Schedule 1 takes that away. And it says basically, after Brexit Day, there is no right to challenge domestic law on several different bases. And that removal of the right applies regardless of when the facts gave rise to the dispute. So you cannot bring any challenge on the basis that an EU measure was invalid. So think of maybe the tobacco directive. You want to challenge UK tobacco legislation that was based on the previous tobacco directive, and you want to knock out the directive. That right is actually still in force, but there's no transitional regime provided for by the bill. And you've got to think of the wider picture, where you can't go to the Commission anymore, you can't go to get a preliminary reference to the Court of Justice, but you can't actually try and enforce that indirectly before the national courts either. So that's going to have quite another large-scale impact on judicial review. Again, there's no challenge on the basis that the UK government's failed to comply with fundamental principles. There's no power for the court to disapply or quash a national measure on the basis that it's incompatible with EU law or general principles. So if the government were to give some state aid, perhaps, to a certain industry operator, and did so in March 2019, which would be in breach of its obligations under the treaty, and there were affected competitors, whether they were UK competitors or competitors from other member states, they would not be able to challenge that decision before the national courts, because Schedule 1 takes that right away. And lastly, there's no right to frank damages. And you may think, well, fine, okay, the government's not going to be held account for breaching EU law. But you would have thought that where you've got a persisting right that hasn't expired, there should be some domestic equivalent of state liability, even if it's just a domestic fashion of it. But there's nothing in the Act to deal with that. So where does this put judges? You know, we've had quite a tumultuous year with all the Miller litigation and the criticism of the judges. And both Lady Hale and the previous president, Lord Neuberger, have made it very clear that they think the Act should have a very explicit provision on what judges are supposed to do when interpreting and applying EU-derived law. Because even though it's not going to be called a directive or a regulation anymore, it's going to be domestic legislation, it's going to have concepts of EU law that have been established for over 40 years. Do the judges carry on interpreting those in the same way, or do they apply their own interpretation? And the Act, or the bill, is very woolly on this aspect. They say that the courts are not bound by any case law post-Brexit, but the judges may have regard to it, and they may adopt and follow it if they consider that's appropriate. And you may think, fine, that's up to the judge, and judges are quite capable of deciding what's relevant and what weight to give. But it's putting the judges in a very hostile environment, particularly with the press coverage that we've had recently, where each decision is going to be accountable to. And we don't have a system like in Europe where the judges produce one judgment and they're anonymous. Here, the judges give their own individual judgment. And so if they have to then give reasons as to why they're not following an ECJ ruling and departing from it, or conversely, why they are, after Brexit, deciding to follow a ruling of the ECJ, it's putting them in a very unenviable provision and the position. And the Act deals purely in very simplistic terms. It deals with rulings of the Court of Justice, but it forgets that there are a number of other important EU institutions that also give out statements or decisions that impact on individual rights. So we've got Commission decisions, you've got the European Medicines Agency, you've got regulatory decision agencies and bodies like BEREC, like the Aviation Security Agency. So all of those decisions need to be taken into account as well. And again, this brings back that there are important ramifications, particularly for regulated sectors, where either if the UK starts to diverge or the EU starts to diverge, it's really going to put the onus on the judges to decide whether they need to maintain consistency and a level playing field, or whether the UK is now going to go off on its own. So I was hoping in that time to have given you a sort of overview of some of the complexities that maybe haven't been under the spotlight. And there are a number of challenges, so some of to the amendments, so some of these may get picked up in the parliamentary process, but I suspect the majority of them will need to be resolved in disputes, and it will be for the litigators and the judges to try and sort some of these issues out. Interesting times ahead. Now you're all sitting